Argumentation Ethics and the Philosophy of Freedom. By Frank Van Dunn. 1. Introduction. In justificatory argumentation, two or more persons seek to justify, or to excuse, a belief or action, to determine whether it is a belief one ought to accept, or to reject, or an action one ought to undertake, or to forego, or whether the circumstances of the case present sufficient reasons, for example, necessity, duress, compulsion, coercion, manipulation, for excusing a person for believing or doing something that is contrary to right. Philosophers, scientists, and lawyers regularly and publicly engage in such argumentations. In fact, most people do the same at least occasionally, albeit in private, at home, at work, in clubs, and barrooms. 20 years ago, Hans Hermann Hoppe presented the argument that no justificatory argumentation can invalidate the principles of libertarian capitalism, because those principles are presupposed in every dialogue in which their validity would be questioned. Moreover, no other ethic could be so justified, as justifying something in the course of argumentation implies presupposing the validity of precisely this ethic of the natural theory of property. In this article, I shall focus on the argument from argumentation itself, rather than on its implications for political economy. My purpose is to clarify the relevance of argumentation, or dialogue ethics, for libertarian theorizing. I shall also endeavor to rebut some frequent criticisms of Hoppe's theory, some of which have recently been revived by Robert Murphy and Jean Callahan, but only insofar as they betray a serious misunderstanding of the argument from argumentation. 2. The argument from argumentation. The key to understanding the argument from argumentation is, first, that when people are told, or asked, to believe, say, or do something, they are likely, and in fact entitled, to question why they ought to believe, say, or do it. And second, that an exchange of arguments is a justificatory argumentation, only if all the participants acknowledge certain facts, and abide by certain norms that no one can argue are invalid, because adherence to those norms is a necessary condition of engaging in argumentation. In short, argumentation does not, and cannot take place in a normative void. Any truth claim is, and must be raised, and decided upon, in the course of an argumentation. And since it cannot be disputed that this is so, this has been aptly called the a priori of communication and argumentation. Now, arguing never consists of free-floating propositions claiming to be true. Rather, argumentation is always an activity too. It follows that intersubjectively meaningful norms must exist, precisely those which make some action an argumentation, which have special cognitive status in that they are the practical preconditions of objectivity and truth. Hence, norms must indeed be assumed to be justifiable as valid. It is simply impossible to argue otherwise, because the ability to argue so would in fact presuppose the validity of those norms which underlie any argumentation whatsoever. For example, one cannot seriously make the argument that one ought not to argue, or that one ought not to take argumentation seriously, without destroying the point of making that argument. A dialectical contradiction emerges when someone states, "You ought to take seriously the argument that you ought not to take argumentation seriously." One who seriously makes an argument, in fact refers himself, and at least the members of his audience to the norm, that they ought to take their own, and one another's arguments seriously, and ought not to dismiss one another's questions or counter-arguments, without giving relevant pertinent reasons for doing so. Thus, when the claim is made that one ought not to take argumentation seriously, and this claim is presented not as a joke, but as a serious proposition for argumentation, then the opposite norm, one ought to take argumentation seriously, is in any case simultaneously posited or presupposed as valid and binding, and is, moreover, argumentatively or dialectically irrefutable. The point of engaging another in an argumentation is to make him understand the reasons or arguments for believing, saying, or doing something, in such a way that he comes round to the conclusion that believing, saying, or doing it is justified as being in accordance with reason. There is no point in getting another to understand why he ought not ask for reasons, or why he ought not answer requests for reasons. Indeed, what shall we make of the argument, here are compelling reasons for why there can be no compelling reasons? Of course, there may be occasions when one should not ask for or give reasons. For example, in an emergency, or when there are other prudential considerations for not trying to engage another in argumentation. Nevertheless, the normative principle, that one ought to act in accordance with reason, remains intact. One is entitled to question whether the emergency or other prudential considerations upon reflection justify or excuse the action. It is also necessary to distinguish between arguing about principles and arguing about particular cases, in which principles are entered as arguments, say, about whether lying in a genuine argumentation is wrong, and whether this particular man in these particular circumstances did wrong to a specific other by lying. In the latter case, one might for example want to inquire if the other, say, an agent of the Gestapo, had a justifiable right to know where the first man's son, suspected of being a resistance fighter, was hiding. In our present academic culture, dominated by empiricism and tainted by its attendant positivism and scientism, prescriptions such as be rational, obey the dictates of reason, or submit to the law of reason, probably sound archaic. Nevertheless, they are all argumentatively valid, and undeniably so. No compelling reasons can be given for not considering them valid. Even people who do not want to be rational, or hate being reminded of such prescriptions, cannot find such reasons. The best they can do is refuse to participate in argumentations, and restrict themselves to one or another variety of sales talk, making appeals to the other's fears and hopes, their greed and vanity, instead of their reason. 3. Dialectical contradictions and dialectical truths. Hoppe's argument raises the question, which norms underlie the praxis of argumentation, and are therefore logically undeniable for any person who claims to take argumentation seriously. However, it is beyond dispute that there are descriptive and normative statements, dialectical truths, that are in any case argumentatively undeniable, and other descriptive and normative statements, dialectical contradictions, that are in any case argumentatively untenable, even if they are neither analytic tautologies or contradictions, nor empirically or mathematically true or false statements. Of course, not every argumentatively justified conclusion is a dialectical truth. Only argumentatively justifiable conclusions, that depend only on arguments referring to the nature and conditions of existence of argumentation, qualify as dialectical truths. I do not dialectically contradict myself when I try to convince my wife that our goldfish is not a rational being, but I do when I set out to convince my wife by rational argument that she is not capable of understanding or producing rational arguments. While asking and answering questions, and getting answers to my questions, I cannot without contradiction maintain that I am, or my opponent in a discussion is, not an answerable responsible person. Thus, in any dialogue, the participants must accept, as a dialectical truth, that each one of them, is a being capable of reason. A person, as I shall henceforth write. Moreover, they must accept, as a dialectical truth, that they are able to communicate and argue with each other, and that each one of them is a separate person, capable of speaking his own mind, and unless specific sufficient reasons to the contrary are adduced, entitled to do so. The point of having a dialogue would be lost if one of the speakers were no more than a mouthpiece for the other, with whom he is supposed to be arguing. There would not be a genuine dialogue if the participants were merely actors reading their lines from a script written by someone else. The very idea of a dialogue presupposes an irreducible plurality of natural persons. Thus, in our argumentation, neither you, nor I, can deny that the other is a separate, independent other person. Moreover, the participants cannot but recognize that they constitute a community of free, separate, independent persons of the same rational kind. Freedom among likes is the presupposition of argumentation, and cannot be denied in an argumentation. It is a dialectical truth that, in the context of argumentation, logic and facts ought to be taken seriously. Any attempt to argumentatively deny, refute, or defeat that norm, would imply the appeal to take logic and facts seriously. Anyone who considered the attempt successful would have to admit that the logic of the argument or the facts it invoked are irrelevant for its conclusion. Similarly, it is dialectically true that one ought to be willing to respond to demands for reasons, or justificatory arguments for, and to accept rational criticism of everything one does, or says. It is a dialectical truth that silencing an opponent by forcibly gagging him, or intimidating him by threatening to inflict harm on him, or indeed on anyone else, is not a permissible move in an argumentation. I'll burn down your house if you dare to disagree with me, or, I'll see to it that your children never get a decent job in this town, is an illegitimate move in an argumentation, no less out of order than, I'll cut out your tongue. Such moves would destroy the conditions under which argumentation can serve its purpose. More generally, it is dialectically true that one ought to respect the physical integrity of one's opponents in an argumentation, not only their bodies but also their property, everything they own, that is, justifiably possess or control, or are justified to repossess, or bring back under their control. This is of course, just another way of stating the respectability of the condition of freedom among likes that I mentioned earlier. It is also a dialectical truth that bribing an opponent, say, by promising him money or a lucrative or prestigious position in return for his not asking certain questions, or only giving desired answers, is not a permissible move in an argumentation. Such a move would vitiate the argumentation. It casts doubt on the opponent's motive in asking questions or answering them, as it would be unclear whether he was engaging in argumentation or merely seeking to bag a reward. Evidently, persons, beings capable of reason, ought to be rational, is a dialectical truth. And, our reason ought to be the slave of our passions, is a dialectical contradiction. The above are examples of dialectical truths, or of dialectical contradictions, some of them descriptive, others prescriptive or normative. Together with others, some of which will be mentioned below, they constitute what I shall call the law of reason. 4. Rationally justified norms. Clearly, engaging in argumentation entails a commitment to abide by a number of norms, because any violation of, or departure from these norms impairs and possibly even destroys the purpose of argumentation itself. These norms come into play whenever questions about the justifiability of actions of any kind, not only moves in an argumentation, are raised and submitted to argumentation. Any action, From merely holding one or another belief, to producing large-scale effects in the physical world, may be questioned with respect to its justifiability. If an action cannot be argumentatively justified, then it is unjustifiable. If it can be argumentatively justified, then it is justifiable. It is a dialectical contradiction to hold that an argumentatively justified conclusion is justified only within the context of argumentation itself. For example, that assaulting another person in the course of an argumentation is unjustified, but that assaulting him afterwards is justified, even if he has not done anything that would justify the infliction of pain or harm. Similarly, because bribing a person in the course of an argumentation is unjustified, it is also unjustified outside the context of argumentation. An argumentation that conclusively establishes that one is justified in claiming truth for a particular proposition, or validity for a normative principle, remains conclusive after the actual exchange of arguments has ceased. Of course, someone who did not hear the arguments may well reserve judgment until he has had a chance to evaluate them himself, but that too is an implication of the ethics of argumentation. However, a blunt refusal to accept the conclusion of an argumentation, unaccompanied by reasons that purport to justify the refusal, cannot commit anyone but the refuser himself, and cannot be considered a justification in itself. A lazy skeptic can effortlessly respond to every argument with, "I am not convinced." But there is no point in engaging a lazy skeptic in an argumentation. Moreover, dialectical truths oblige not just the actual participants in a dialogue in progress, but all human persons. Justificatory argumentation appeals to reason, not to subjective preferences or personal quirks. It is easy to refuse another person the opportunity to present his arguments, questions, and answers, and thereby avoid having an argumentation with him. Nevertheless, such a refusal is not a conclusive rational proof that he is not capable of reason. A's refusal to speak to B does not prove that B is beyond the pale of argumentative intercourse. Treating a person as if he were not a person is not justifiable on the mere ground that one has denied him the opportunity to prove himself capable of reason. It is dialectically true that in dealing with one's likes, other human beings, one ought to presume that they are persons, at least until there is sufficient proof that they are not. The contrary presumption, that other people are not capable of reason anyway, is a dialectical contradiction, because it amounts to an a prioristic refusal to take their arguments seriously. It amounts to a refusal to even recognize their arguments as what they are, arguments. The presumption of rationality is implied in the practice of argumentation itself. Obviously, the presumption of rationality is defeasible in particular cases. There may be occasions when someone is temporarily out of his mind, or definitively loses his mind. Moreover, every human being goes through a stage early in life when his rational faculties and his knowledge of the world are still insufficient to allow him to participate in argumentations. However, it is customary not to hold young children responsible for their actions, and customary to hold grown-ups responsible for their actions, unless the particular case reveals sufficient reason to think otherwise. Few people are inclined to question whether this is a rationally justifiable custom, and with good reason, I should think. If a man proves himself an animal capable of reason, by engaging others in argumentation, then he is a person and ought to be regarded and treated as such by other persons. My questions and answers do not magically transform a non-rational blob into a responsible, answerable being capable of reason, who will once again become a non-rational blob as soon as I turn my back to him, nor am I so transformed by another's questions and answers. There is no more evidence for the contrary proposition than there is for my saying that things exist only when I have an immediate sensation of them. Moreover, to assume the contrary would make all argumentations about anything other than the current argumentation itself pointless, and that would make the current argumentation pointless. If there are norms that are undeniably valid for persons capable of arguing and actually participating in an argumentation, then they are valid for all persons capable of arguing, even at times when they are not participating in an argumentation. Such norms are not like, say, the rules of chess that bind chess players only while they are playing the game. There is no a priori of chess to match the a priori of argumentation. The ethics of argumentation does not contend that whenever people are engaged in a debate, they have implicitly agreed to certain norms. To accept that contention is to uproot the argument from argumentation, and reinterpret it as an argument about a game defined by rules that the participants have agreed upon. If that were the case, then obviously only the participants in an actual argumentation would be bound by those rules, and only for the duration of the argumentation game. However, the point of the a priori and the ethics of argumentation is that in order to participate in an argumentation, people must accept the norms that are implied in the nature of argumentation. Whether an exchange of questions and answers is, or is not, an argumentation, does not depend on agreement, implicit or otherwise, on an arbitrary set of rules, but on compliance with the norms which must be adhered to, if the exchange is to be an argumentation. Unlike the rules of chess, which define by stipulation what the game of chess is, the rules of argumentation are to be discovered in the nature of argumentation. Similarly, whether A proves B is not a matter of convention, but of logic. Although B does not follow logically from A, it is nevertheless the case that A proves B, because we have agreed that a proof is constituted by rules that are different from the rules of logic, is no more than a roundabout way of saying A does not prove B. To sum up, it is a dialectical truth that one should respect one's opponents in an argumentation as free and independent persons, whom one should not even try to manipulate or intimidate with anything other than the force of one's arguments. Moreover, one cannot argue with dialectical consistency that argumentatively unjustifiable ways of dealing with other persons justifiably prevail outside the context of argumentation. Those others might be one's opponents in a future argumentation. Therefore, there can be no justification for having recourse to such ways of dealing with such others. In short, persons ought to respect their likes as free and independent persons. Whether or not this is the principle of libertarianism or libertarian capitalism, it is in any case the rationally demonstrable foundation of the classical natural law ethic, the normative framework, the law of reason, within which natural persons, human beings, insofar as they are capable of reason, ought to solve their differences, disagreements and conflicts. Within this framework, a jurisprudence of freedom can propose and critically consider ways in which people ought to or may interact in various sorts of situations, without violating the normative requirements implied in their nature as beings capable of reason. 5. Significance for the history and philosophy of law. A man accused of having committed a crime does not prove his innocence by proving that he committed no crime during the whole time he was in court, where his case was being argued. The point of the argumentation in court is to determine whether some particular action of his, before he was hauled into court, was justifiable or unjustifiable, excusable or inexcusable. If a man proves his innocence with respect to a crime of which he has been accused, a judge would dialectically contradict himself if he were to say, "Congratulations, but I am going to hang you anyway." After all, it does not follow from the fact that you gave proof of your innocence that anybody ought to pay attention to it, especially after the trial is over. An agent, officer, or magistrate in the service of the government might say such a thing without dialectical contradiction, but only if he makes no claim to do justice. An official condemns a man to the gallows, having heard only the arguments and witnesses of the prosecution and having denied the accused the right to defend himself. There is not a whiff of dialectical contradiction there as long as the official places himself in the realm of brute force or cunning manipulation, demonstrating by words or actions that he does not intend to justify his action. However, he would dialectically contradict himself if he were to go on to say that he has rendered justice and spoken truly as required by the ethics of argumentation. He would also dialectically contradict himself if were to attempt to justify his refusal to justify his obviously unjust actions. Perhaps the greatest merit of Western civilization was that for a remarkably long time, it accepted the normative primacy of reason in human affairs as the foundational principle of justice. This was the paradigm of natural law, which, in the words of St. Thomas Aquinas, amounted to the recognition of man's rational participation in the eternal law. Few thought of arguing against the principle that conflicts, disputes, and disagreements ought not to be settled otherwise than by means of rationally justified actions in accordance with rationally validated principles. Force, intimidation, manipulation and so on may be excused on those occasions when they are used as means in ultima remedio to help establish or re-establish justice, but never when they are used autonomously to bring about whatever one can get away with. Thus, it was accepted that there is a court of reason and that men should, indeed, ought to have and organize actual courts of justice to help ensure that reason should prevail. The idea of a court of justice as an island of reason, where arguments would be appreciated on their merits, and where attempts at intimidation, trickery and so on would be checked and weeded out, became central to the ideology of the West. Inside the courts the ethic of dialogue or argumentation should reign supreme, regardless of how it fares in the rough and tumble of daily intercourse. Moreover, the findings of such a court, with respect to the justifiability of particular actions, should prevail over the emotional or calculated responses of those who witness or hear about them, at least to the extent that the court's findings are justifiable. Only reason can justify, and that reason is not manifested in a monologue of one side's arguments, but in a dialogue, where arguments and counter-arguments can be evaluated in an open confrontation. Thus, it was taken for granted that a court ought to hear all the parties involved in a dispute and give them an opportunity to justify or at least excuse their actions audi et alteram partem. That judges should arrive at the truth of the matter in their verdicts, that is, veredicta or truth-sayings, solely on the basis of the merits of the case as they emerge from the accounts of reliable witnesses and the arguments presented in court by the parties to the conflict. And that these verdicts should have normative authority as long as they are not shown to be wrong, that is, not veredicta after all. Whatever the degree of social, economic or political inequality in a society, respect for the process of finding justice and a commitment to uphold its findings were held to be the keys to freedom and justice. The courtroom should provide the conditions that make fair argumentation possible, equality before the law, and, via the practice of permitting the parties to call on advisors and advocates, even a rough equality of intelligence and argumentative skills. It was a great idea, but of course the powerful, the rulers and their clients, often enough intervened in court proceedings and made a mockery of the independence of the courts of law, replacing them with boards of officials whose main function was, and is, to see to it that their master's voice is heeded by all. The judges were replaced with magistrates. The jurists, whose main concern is the knowledge and application of the principles of justice, were replaced with legists, whose main occupation is to know and apply their master's wishes as these are revealed in legal edicts and codes. Nevertheless, even in this day of rampant legal positivism, the ideals of justice still fashion the way in which those boards and magistrates present themselves to the public at large and to their masters. Unlike bureaucrats and diplomats, the magistrates posing as judges do not claim authority on account of their loyal subservience to their masters, but on account of their independence from them. Paying lip service to the ethics of dialogue and argumentation is vitally important for maintaining not only their position in society but also their status as possessors of a science of necessary things. While positivism rules the curriculum in the law schools, telling their students that only the law matters and that the law is nothing but the set of legal rules, edicts and decisions promulgated by the authorities that other rules in the same set designate as legal, the schools never tire of instilling in their students the sense that the implications of positivism do not apply to the magistrates and the advocates they are being trained to become. Like scientists, they should be aware that they are supposed to answer to a calling that transcends loyalty to any social or political regime. Like scientists, they should feel entitled to claim immunity from arbitrary interference, admittedly not as a general human right but as a professional privilege. And like scientists in the age of big politicized science, they should not have any qualms about serving and assisting the powers that be as long as the latter keep up the pretense of their independence. Albeit in an increasingly emaciated and perverted form, the ethics of argumentation still has a hold on the imagination as the bulwark of civilized coexistence, no matter how obscure the distinction between a scientist and a government expert, or between a judge and a magistrate, has become in public discourse. However, its force is sapped when the point of argumentation in a court no longer is to reveal which actions are justifiable and which are not but merely to determine which party complied with some set of arbitrary politically imposed rules. Then argumentation gives way to a contest in which one legal mind tries to outwit his opponent in a game that turns primarily on one's skills in combining officially recognized legal classifications of facts, legal rules, other legal data such as precedents, and currently fashionable notions into a strong case. Similarly, the ethics of argumentation and dialogue loses its grip on the intercourse of scientists if convincing the authorities of the social or political relevance of one's research becomes a priority. The argument from argumentation is not a mere academic artifact without any practical significance. It underlies the Western tradition of the philosophy of law and its impressive harvest of principles of substantive and procedural justice, which command respect even after more than a century of systematic debunking at the hands of scientific positivists and others for whom man's reason counts for nothing and his vote for everything. 6. To argue or not to argue. With few unfortunate exceptions, human beings are capable of reason. Unfortunately, many people prefer not to upgrade to the condition of an animal rationale by accepting or at least striving to live within the law of reason. Many are opportunists, who appeal to the laws of reason, if at all, only when it suits them. For them, what is in it for me? Is a far more pressing question than, what is the right thing to do? Consequently, they prefer to get by on the basis of prudence rather than wisdom, prudence controlled by reason, just as they would do in their interactions with animals and other natural phenomena. Nevertheless, Few people can resist the urge to distinguish between right and wrong, and to claim justification for their judgments in matters of right and wrong. However, many want the reward of justification without arduous argumentation, and are likely to settle for prejudices rather than well-argued judgments. Many people would sooner die than think. In fact, they do. That is not a refutation of the law of reason, but an indication of man's imperfection in the light of his most distinctive faculty, reason. Consider Jonathan Swift's statement, that I have chosen as a motto for this paper. No person can disobey reason, without giving up his claim to be a rational creature. It expresses a dialectical truth: reason ought to be obeyed, for one cannot consistently argue that reason ought not to be obeyed. It also states an argumentatively justified consequence of disobeying reason: one thereby gives up the claim to be a rational being, for one cannot consistently argue that one is a rational being, and reject the obligation to abide by the dictates of reason. Recall that Swift defined the human being as an animal, capable of reason, not as a being that is always, and everywhere, as it were automatically, in tune with reason, but as one for whom it is a matter of choice, whether or not he or she will accept to be rational, to live or to strive to live, to accept to judge and be judged, in accordance with the dictates of reason. Obviously, it is physically possible for a human being to refuse to place himself under the authority of reason. However, he cannot without dialectical contradiction argue that the dictates of reason do not apply to him but only to others. The same holds for a man who wants to claim his rights according to the ethic of argumentation but refuses to recognize the obligations it imposes. That too is an argumentatively untenable position. Men who refuse to be bound by the ethics of dialogue or argumentation cannot hope to succeed in justifying that position argumentatively. Such people choose to act, and to interact with others, outside the realm of reason. Placing themselves outside the law of reason, the context where appeals to reason or justice can meaningfully be made, they choose to be outlaws. They not only give up the claim to be rational persons, they also free all others from the rationally, argumentatively valid obligation to treat them as persons according to the dictates of reason. The point is that whether or not one activates one's rational capabilities is a matter of choice. We can choose to enter into civilized commerce with one another by accepting the a priori of argumentation and all that it entails, or we can refuse to do so and play the Hobbesian jungle game. Some will choose the second option, thereby waiving their rights under the law of reason and justifying others to treat them as wild things, which one can try to manipulate but with which it is pointless to argue, and if they do injury contrary to right, justifying others to treat them as enemies. There is no contradiction in their choice, as long as they do not pretend to be able to argue that placing themselves outside the law of reason is the right thing to do. Indeed, some people succeed remarkably well in placing themselves outside, or above, the law of reason. Nevertheless, they, their supporters, clients and apologists, cannot ever justify their stance in a rational argument. They may not care about that as long as they get their way, but that is their choice. It is not an argument with any rational force. Their choice to make themselves outlaws in no way invalidates the laws of reason. 7. Outlaws and the presumption of innocence. Hoppe had no pressing reason to discuss the concept of an outlaw in the context of his comparison of socialism and capitalism. Nevertheless, the concept is essential for a correct appreciation of argumentation ethics. Not understanding this, critics such as Murphy and Callahan assume, 1. That Hoppe's theory implies that criminals are self-owners, who cannot rightfully be punished for their crimes because punishment violates their self-ownership. And 2. That, if the theory should deny that criminals are self-owners, it cannot claim self-ownership for anyone. If Hoppe's argument doesn't prove that criminals own themselves, then it can't prove that non-criminals do, either, since there is nothing in the argument itself concerning criminal behavior. Against Murphy and Callahan's reading of it, we must point out that the argument from argumentation clearly distinguishes between persons who stay within the law of reason, and persons who avoid or evade that law. Among the former, self-ownership is argumentatively undeniable. Among the latter, the question of ownership as distinct from effective control, let alone self-ownership as distinct from effective self-control, does not even arise. Of course, rational persons may be justified in using violence against a brute or a criminal, that is, one who is by nature or by his own volition outside the law of reason, incapable or unwilling to submit to the test of justificatory argumentation. The ethics of argumentation restricts the range of one rational being's lawful actions with respect to other rational beings, who like him accept that actions should be justifiable. It does not impose restrictions on what a rational being may do to a rock that threatens to crush his home, a bear that threatens to tear him apart, a criminal who tries to rob him, a thing that is outside the realm of the law of reason, or a man who makes himself an outlaw, say, by fleeing from justice or refusing to make restitution to those he has unlawfully wronged, is not, or is no longer, in the same position as one who continues to submit to the law of reason, or as the repentant robber who recognizes that his actions were unjustifiable and makes a genuine offer of full restitution to his victim. Murphy and Callahan simply assume that bashing the head of an outlaw, a brute or an unrepentant robber, is just as much a violation of an argumentatively justifiable property right, as is bashing the head of an innocent person or a repentant criminal. They are wrong. My argument here refers to the theory of crime and punishment implied in the ethics of argumentation, a theory that is familiar to libertarians. Its bare outline is as follows. Suppose that one person, T, a tortfeasor, intentionally or unintentionally, voluntarily or involuntarily, caused unlawful harm to another, V, his victim. Then there is an argumentatively justified obligation for T to undo, or compensate for, all the harm he caused V to suffer. This obligation corresponds to V's right not to suffer unlawful harm from another person. If T readily demonstrates his willingness and ability to make full restitution to V, the two must rely on negotiation, mediation, arbitration or adjudication to determine how and when full restitution is to be made. As soon as full restitution is made, the matter is settled, and V has no right to demand or extract more from T. In particular, V has no right to punish repentant T. However, if T refuses to honor his obligation to make restitution, for example by trying to evade being brought to justice, then he turns himself into a criminal. Consequently, V has the right to enforce his claim against an repentant T, who is now no longer a mere tortfeasor but a criminal. Thus, we have the presumption of innocence, that is, the principle that no person shall be considered a criminal, or punished as a criminal, unless he willfully places himself outside the law of reason. Any animal capable of reason is to be presumed to accept the law of reason until it demonstrates that it does not. However, one who does place himself outside that law, not only gives up his claim to be a rational person, but every other claim as well that invokes that law, including claims to ownership or self-ownership. As will become clear in the next section, none of this implies or even suggests that claims of ownership and self-ownership cannot be justified within the law of reason. 8. self-ownership as seen through positivist spectacles. Argumentation ethics does not fit the modern academy's dominant paradigm of empirical science and its attendant positivistic and scientistic methodologies. It is therefore no surprise that many of the academic critics of argumentation ethics have no use for it. Normative propositions such as, being capable of reason, human persons ought to be rational, simply do not pass the positivists' muster and should therefore never be used in scientific reasoning. Positivists do not care to argumentatively justify their rejection of such propositions. Dialectical truth and dialectical contradiction are not in their methodological or epistemological repertoire. They do not, of course, deny that they themselves are capable of reason, and they do not deny that in their academic discourses they ought to show respect for truth and logic, ought to be willing to produce reasons or justifications for, and to accept rational criticism of, everything they do or say, ought to respect each other as free and independent persons who should not even try to manipulate or intimidate one another with anything other than the force of their arguments, and indeed ought to respect the full range of libertarian rights insofar as they are relevant for academic intercourse. They are, however, unlikely to consider these norms rationally justified or even justifiable. They are far more likely to consider them as no more than conventions or rules of the game, like the rules of chess. In the perspective of positivism, such rules are not grounded in a rational appreciation of the essence or final form of science. Rather, they happen to be the rules effectively followed by people who are conventionally regarded as scientists, and at least tolerated by public opinion and public authorities, the powers that be. Consequently, the norms implied in argumentation ethics can enter the discourses of positivists only as mere conventions, or as perhaps disguised empirical statements. Thus, we may expect two sorts of attack from positivists on any presentation of argumentation ethics such as Hoppe's. 1. Argumentation is a conventional game, and as such its rules have binding force only for those who play the game, and only for the duration of the game. 2. The ethics of argumentation implies empirical generalizations, which can be shown to be false by suitable counterexamples. Murphy and Callahan, indeed, try both sorts of attack, although they certainly would not like being labeled as positivists. They sum up their critique as follows. Even on its own terms, Hoppe's proof at most establishes fleeting and partial ownership of one's body. His proof doesn't even succeed in this, for it confuses temporary control with rightful ownership. The first sentence says that Hoppe has only shown fleeting ownership of one's body, namely, ownership for the duration of the argumentation, and even so only partial ownership, namely, ownership of those parts of one's body that one effectively needs to participate in an argumentation. The second sentence states that Hoppe does not demonstrate ownership, but only effective use of those parts of one's body. As we have seen already, the fleeting ownership criticism fails. What a justificatory argument justifies, whether or not that is an ownership claim, is justified not only while the argumentation is in progress, and not only for those who actually participate in it, but for all time, and for all actual and potential arguers, for all persons. This is also true for the validity of the norm. Beings capable of reason ought to respect each other as free, independent, separate persons, which implies that they ought to abstain from using force or other non-rational means against one another unless there is justification for resorting to such means. As Hoppe put it, nobody has the right to uninvitedly aggress against the body of any other person and thus delimit or restrict anyone's control over his own body. This rule is implied in the concept of justification as argumentative justification. Since according to the non-aggression principle a person can do with his body whatever he wants, as long as he does not thereby aggress against another person's body, that person could also make use of other scarce means, just as one makes use of one's own body, provided those other things have not already been appropriated by someone else but are still in a natural, unknown state. Clearly, it cannot be concluded from this that all human beings per se are self-owners. Moreover, there is no reason to suppose that the argument intends to show that all human beings as such are self-owners. Why then do so many critics seem to assume that the argument intends to prove precisely that, and therefore fails because it does not? At best, Hoppe has proven that it would be contradictory to argue that someone does not rightfully own his mouth, ears, and any other bodily parts essential for engaging in debate. But that clearly would not include, say, a person's legs. It is dialectically true that the participants in an argumentation must have physical control over some parts of the world, and in particular of their own bodies. This does not mean, however, that participants in an argumentation must have or even must be presupposed to have ownership of those parts of the world or their bodies. Ownership, unlike possession or effective control, is not a merely physical relation. Ownership means justifiable control, that is, argumentatively justifiable control. Therefore ownership can be determined only as the result of an argumentation about the justifiability of a person's having possession or control of one or another means of action. Nevertheless, Murphy and Callahan consider it a more fundamental objection that one is not necessarily the rightful owner of a piece of property, even if control of it is necessary in a debate over its ownership. That proposition is simply true, but the question is whether it is a relevant objection to Hoppe's argument. Suppose I am charged with a crime in China. To comply with some minimal requirements of justice, the Chinese court concedes that I should be assisted by a competent translator. I need one, to be able to participate in the arguments made in court. Yet, my need for such a translator does not prove that the one I eventually get is my property. Did Hoppe say anything to suggest otherwise? I cannot find any place where he logically committed himself to such an absurdity, and Murphy and Callahan do not direct me to one. Instead, they attempt to make Hoppe sound as if he were a Georgist. The insinuation is pointless. The fact that I need standing room in the Chinese court in order to be able to attempt to justify my actions does not make me the owner of a little piece of China. The Chinese are not contradicting themselves in conceding me standing room in the court without granting me ownership rights in Chinese soil. Murphy and Callahan suggest that if the Chinese are not contradicting themselves, then also one who concedes another the use of his body or some parts of it, for the duration of the discussion is not contradicting himself if he denies the other ownership of his body. True enough, denying that some person is a self-owner is not per se a dialectical contradiction. But that does not mean that his claim to be a self-owner, that is, his claim that only he has justified and indeed justifiable possession and control of his body, cannot be justified. Murphy and Callahan also claim that a theist may be wrong in asserting that God owns all of us, but insist that he is not thereby contradicting himself. Therefore, or so they say, the thesis of self-ownership is not without a logically coherent alternative, and so cannot be necessarily true. They fail to see that a dialectical contradiction is not a contradictio in terminis, but a contradiction between what is said and the saying of it. In this particular case, they moreover fail to note the difference between arguing about God and arguing with God. The question of God's ownership would have to be decided in an argumentation with God, not with any self-proclaimed representative of God, who would have a hard time proving his credentials anyway, so much so that it is doubtful that he would ever get to discuss the question of God's ownership itself. The same applies to discussions about society or the people's having ultimate ownership of our bodies or other things. The concept of ownership makes sense in the context of argumentation, the moral sciences, not in the context of describing the interaction of merely physical forces, the behavioral sciences. Unless I am prepared to argumentatively justify my actions and to accept justifying arguments made by or on behalf of others, in short, unless I agree to live within the law of reason, I cannot without dialectical contradiction claim ownership of anything, including ownership of myself. A wild animal, no matter how strong and cunning, makes no ownership claims. A man who does not care about the dictates of reason cannot consistently claim that his control over or use of some parts of the universe is to be respected because it is argumentatively justified. In many cases, of course, possession or effective control is unjustified, even unjustifiable. The argument from argumentation does not deny that. But neither does it deny that there are cases of justified or justifiable possession or effective control. Recall once more Swift's definition of man as an animal capable of reason, bound by the argumentatively undeniable norm that it ought to be rational. Swift concluded, no person can disobey reason, without giving up his claim to be a rational creature. We can now add, giving up the claim to be a rational creature entails giving up the claim to be a self-owner, or indeed an owner of anything whatsoever. One who places himself outside the law of reason, thumping his nose at justificatory argumentation, cannot consistently claim to own what he possesses or controls. In contrast, a person who lives within the bounds of reason will have no difficulty proving justifiable possession of any part of his body or indeed of any other thing that he acquired without injustice to anyone. After all, one cannot without dialectical contradiction presume that another person does not own his body. A person is to be regarded as a self-owner unless and until specific reasons are adduced for holding that his control of his body is not justified. It would be a dialectical contradiction to deny this. There is no point to engaging in an argumentation with someone who believes that no person has a right to use his body to express himself or to speak his mind. To appreciate the undeniable justifiability of the presumption of self-ownership, it suffices to step out of the rarefied atmosphere of academic discourse, where self-ownership is just a word or free-floating concept. Let us sit down, you and I, and facing one another argue about who may be presumed to own, justifiably control, whom, I me and you, self-ownership. I you and you me. I both of us. You both of us. I and you both of us. Or none of us either of us. Chances are that you and I are already in the perfect condition for an argumentation of that kind, if there is no prior event that has caused one of us to be indebted or subordinated to the other, say, as debtor to creditor or criminal to victim. It will soon become obvious that the presumption of self-ownership is the only argumentatively robust principle in the list, the only one that is part and parcel of the factual and ethical presuppositions of argumentation. Of course, from the perspective of positivism, this explication is to no avail. For the positivists, justification adds nothing to anything and ownership reduces to effective possession. Either actual possession or possession recognized and protected by the powers that be. Ethical notions must be eliminated from scientific reasoning, if not by simply ignoring them then by reinterpreting them as merely empirical concepts. Disregarding Hoppe's explicit protestations, even Murphy and Callahan prefer to interpret Hoppe's dialectical statements about ownership as empirical statements about the physical preconditions of the ability to speak and to attack him by means of empirical counterexamples. Hence, their reference to the fact that a person without legs can argue with others, and their conclusion that, since legs are not needed for the purpose of communication, Hoppe's argument cannot even account for the fact that a person owns his own legs. Hence also, their reference to slaves. These do not enjoy libertarian rights, yet are able to argue. Therefore, or so Murphy and Callahan claim, libertarian rights are not necessary for the ability to argue, and Hoppe's argument cannot account for self-ownership at all. However, because the general empirical statements against which they are directed are not part of Hoppe's theory, the counterexamples do not affect the theory in the least. Hoppe's argument is not that, "This is mine," follows from "I need this to be able to participate in an argumentation," because it would be contradictory to say, "Indeed, you need it, but I deny that it is yours." The argument is that when A and B enter into an argumentation, both of them do so under the dialectically valid presumptions of rationality, innocence, and self-ownership, presumptions that will hold until there is proof that they should be withdrawn. Neither A nor B can deny that he is arguing with another person, one who is both a person and another person, in the words of the time-honored formula, a separate free and equal person. Neither of them can justifiably claim to own any other participant's justifiable possessions, his body or any part thereof, or any other, non-somatic means of action, or, of course, the law of reason itself. However, the fact that an outlaw needs his tongue to utter or his hand to write statements, does not mean that he owns these body parts. One cannot at the same time repudiate the law of reason, which is what a criminal does, and invoke it to prove justifiable control, that is, ownership. Murphy and Callahan then claim that, even if one sets aside their remarks about fleeting and partial self-ownership, it's still the case that Hoppe has only proven self-ownership for the individuals in the debate. For example, so long as Aristotle only argued with other Greeks about the inferiority of barbarians and their natural status as slaves, then he would not be engaging in a performative contradiction. That is not true. Aristotle's general statement that barbarians have enough reason to obey orders and please their Greek masters, but not enough to qualify as fully human, is not defensible in an argumentation. If Aristotle had tried to justify his views to a moderately articulate barbarian, the contradiction would have been obvious. He could only try to avoid the humiliation of being caught in a dialectical contradiction by refusing to justify his views to the so-called barbarians, by refusing to give them a hearing. However, the attempt would have been in vain. For that refusal itself is a contravention of the ethics of dialogue and argumentation. It exemplifies not simply an intellectual mistake, but a morally vicious stance. Any person, Greek or non-Greek, could have made that clear. There is no way in which Aristotle, the philosopher, could have argued that his refusal to let the barbarians speak for themselves was argumentatively justified. Refusing to argue is not a form of producing an argument. There can be no argumentative justification for Aristotle's refusal to put his statements to the only relevant test. Engage a non-Greek in an argumentation. After all, Aristotle was not merely stating the obvious, namely that the sentence, "Greeks are rational in a way non-Greeks are not," is not a contradictio in terminis. Yet, Murphy and Callahan claim without argument that Aristotle's refusal to talk to barbarians is as justified or as unjustified as our refusal to try to justify our views on zoos to a polar bear or a horse. The Hoppian might respond that horses are not as rational as humans, and therefore do not need to be consulted. But Aristotle need only contend the same thing about barbarians: they are not as rational as Greeks. What sort of argument is that? Do I need only contend that I am the only rational person in the world, to justify the claim that nobody else is capable of arguing? We should soon discover that polar bears and horses are not creatures with which it is wise or safe, or indeed possible to reason. Are Murphy and Callahan suggesting that that is exactly what Aristotle would have discovered if he had had a face-to-face discussion with a barbarian, any barbarian, and that he was therefore justified in refusing to give any barbarian an opportunity to prove him wrong? Murphy and Callahan's contention, that refusing another person a hearing is just as rationally justifiable or unjustifiable as not giving animals a forum in which to expound their views on zoos and animal rights, is ridiculous. It is precisely in the context of argumentation that we cannot overlook the difference between another person and another animal, without making complete fools of ourselves. In defense of Murphy and Callahan, one might point out that academics, including most economists and social scientists, tend to deem scientific only theories about humans beings that treat them not as potential opponents in an argumentation, but only as suitable matter for empirical research. I should think that that is a fundamental flaw in much of contemporary social and economic science. In an inquiry relating to the foundations of ethics, it is utterly out of place. Murphy and Callahan then refer to David Friedman, who argued that Hoppe must be wrong when he claims that self-ownership is a prerequisite to debate, because countless slaves have engaged in successful argumentation. However, Hoppe did not make the empirical and absurd claim that a person is incapable of arguing merely because the powers that be legally classify him as a slave, or that being the legally recognized owner of one's body is a necessary condition for being capable of engaging in argumentation. His argument was that such legal classifications and the actions they sanction or legitimize cannot be justified in an argumentation with the slaves, or indeed in any argumentation that takes the presuppositions of argumentation seriously. Consider, on the one hand, a master who enjoys debating the justifiability of slavery with his slaves after dinner and then sends them back to their cage, no matter what the outcome of the discussion may be. Consider, on the other hand, a master who frees his slaves after being exposed to the argument that slavery is not justifiable. Which of the two takes argumentation seriously? Which of the two acts as a rational being rather than a mere animal capable of reason? The first master obviously regards argumentation as no more than a parlor game. He refuses to argumentatively justify his actions outside that game and to make them conform to justified principles. He demonstrates by his actions that he does not take argumentation seriously if it does not suit his purposes. Why should his opponents in the discussion, his slaves, take the argumentation in question seriously? Why should anyone? Hoppe answers, no one should take that argumentation seriously because it is not a genuine argumentation. Embracing Friedman's avowed positivism, which instructs him to find an empirical difference between the moves of a genuine argumentation and those of a mock argumentation, Murphy and Callahan jump to the conclusion that they have refuted Hoppe. They are mistaken. To refute the Hoppian argument from argumentation, they would have to show that the first master and his slaves can with dialectical consistency engage in serious argumentation, accepting the dialectical principles such argumentation entails. Murphy and Callahan do not even try to make that argument. Recall that Aristotle defended slavery with the argument that it is not primarily a conventional institution but a natural and justifiable condition of inferior people. His defense failed, as we have seen, because contrary to the requirements of the ethics of argumentation he had refused to submit his reasoning to the only test that could decisively refute it. The scandal of slavery is not in the fact that slaves are not, let alone cannot be, self-owners, but in the fact that most of the people held as slaves are self-owners, and justifiably deprived of their freedom. In other words, the scandal of slavery has very little to do with the persons held as slaves, and very much with the people holding them unjustifiably as slaves. 9. The fallacy of scientism. The conventions of academic writing tend to prevail over the requirements of the ethics of argumentation, even where adherence to those conventions leads to scientistic fallacies. The basic convention is the subject-object distinction, in particular, the notion that the subjects, the researchers, and the objects of their research are qualitatively different sorts of entities. That notion is appropriate where the subject is a human person and the object some non-human, non-personal form of life or matter. However, it is inappropriate where both the subjects and the objects are human persons. There is a difference between theorizing about the human world as if it were a separate realm of things with which we can have no intellectual, argumentative intercourse whatsoever, and theorizing from within the human world about the human condition. The scientistic fallacy results when academics pretend to study the human world from the outside, as if they, rational beings, are no part of it, as if the objects of their study, human animals or, perhaps, mere black boxes, are as different from them as are snails or crystals. On the one hand, the academics recognize that in their own disputes, where they face one another, they should abide scrupulously by the requirements of the ethics of dialogue, if they want to be accepted as members in good standing of their academic communities. Thus, in the communications and argumentative exchanges within their academic community, ill-defined as it may be, they fully accept that argumentation is between one person and another, between an I and a you, and also that the success or force of the argumentation does not depend on who is the I and who the you. On the other hand, people outside the academic community should never be considered even a potential you or I. They are assigned the status of an impersonal it or them, and should not be regarded as rational persons of the same sort as the academics who theorize about them. Consequently, it makes no sense to think that among themselves those human animals or black boxes are rationally bound by, and entitled to treatment according to, the ethics of argumentation in the way the academics are. As a corollary, statements about ordinary people should not be applied to the academics themselves. The scientistic and positivistic insistence on a radical subject-object dichotomy between us and them precludes that the two sides of the dichotomy are united by any a priori of argumentation. Indeed, scientism requires that the rationality of ordinary people be methodically disregarded. Their arguments must be reinterpreted as instances of mere behavior to qualify as legitimate scientific data. In a similar vein, the ethical notions that define the academic community must be emptied of their primary ethical content before they can be applied to the human objects of research. As Anthony de Jassé memorably put it with respect to justice, unless justice is defined as something else than justice, it has no place in the contemporary academy's scientific research concerning the human world. Justice is no more than a subjective relative value, or it is a nominal standard imposed by the scientific observer that answers, say, to this or that quantifiable maximum, or this or that calculable condition of equilibrium in the pool of human matter. Libertarianism likewise must boil down to the mere belief that ordinary human beings have more or less the same rights relative to each other, as academics have in their academic community. However, any justification of that belief about the ethics of beings outside the academic community of scientists must be different in kind from the justification of the ethics of the academic community itself. Indeed, the subject-object dichotomy implies that rational, argumentative capacities cannot have the same kind of ethical implications for ordinary people that they have for intellectuals. Consequently, an academic's commitment to libertarianism as a valid principle for all human persons has the same sort of contingent relation to the ethics of argumentation as any opinion or theory of animal rights has. If the separation of mankind in two distinct species, we, the arguers who make up the academic community, and they, the black boxes we define as relevant behavioral units, is made into an axiom of the scientific study of the human world, the relevance of our ethical principles to ordinary mankind must be as contingent, arbitrary or delusional as it is to mosquitoes or black holes. Hoppe explicitly refuses to accept that axiom. He most certainly does not appeal to the prevailing consensus in, or the mere conventions of, any particular human community, no matter how it labels itself. He appeals to the capacity of all human persons to recognize one another as persons, at least when they get involved in asking questions and giving answers, and arguing about the reasons for their questions and answers. In scientistic positivism, the critics of argumentation ethics may well find all the arguments they need for their belief that an academic does not formally contradict himself when he says that human or other animals do or do not have one or another right. True as this is, it does not amount to an argumentative justification of any form of scientistic positivism, unless, of course, it were true that academics belong to a different species than ordinary men and women. The beneficial influence of scientistic positivism emerges most clearly in the context of education. What happens to education when the a priori ethic of argumentation no longer binds teachers and pupils in a single community of rational persons? The enthusiasm with which many academics support, say, Hume's dictum that reason is and ought to be the slave of the passions, as if it were a deep insight into the truth about human nature, raises the question what sort of education could be built upon the positivist principle as it is applied to human affairs. At the individual level, it translates into, your reason is and ought to be, the slave of your passions. Do not question your desires, only the efficacy and efficiency of the means to realize them. At the institutional level, it translates into, say, schools and universities. The pursuit of scientific knowledge itself, are and ought to be the slaves of politics, or if not of politics then of public opinion. In either case, we seem to be left with no principle of education at all, for what is the purpose of an education if not to teach us to learn to discern right from wrong? Hume never leads us beyond the question of how to get what we want in the most efficient way, no matter what we want. To give only one example, increased unemployment of certain classes of men may be an almost inevitable consequence of imposing an effective minimum wage. Some people, those who see their employment opportunities diminished or their labor costs increased by such a measure, will say that that is a reason for not imposing a minimum wage. Others, employers fearing competition from regions with lower wage rates, union members seeking to restrict entry into the labor market, politicians looking for a client base of people dependent on political redistribution, and those hoping to become clients of such redistributive schemes, will say that it is a reason for imposing a minimum wage. Hume in reason, having established the relation between minimum wage legislation and unemployment, sits back until the balance of power among the passions tilts towards a particular goal and then enlists itself in the service of the winner. Education, based on Humean reason, teaches service to the ruling passion or opinion, in a word, conformism. Questions of right and wrong, justice and injustice, and the presumptions of rationality, innocence and self-ownership, lie outside its scope. At best, Such questions are admitted only after they have been reduced to questions of compliance with existing, merely conventional rules. Of course, there is no reason to suppose that what lies outside the scope of human reason is irrelevant and cannot be subjected to justificatory argumentation. The effects of the adoption of Hume's principle in education are easily observable in the proliferation of experts and social and economic theories that, while claiming to be scientific, are examples of sophisticated sales talk promising the greatest happiness to those who adopt them. 10. But does it justify libertarianism? While I was working on my ethics of dialogue, some people began to call me a libertarian because of the considerable overlap between the conclusions I reached, in particular about the state being unjustifiable, and positions defended in the writings of Murray Rothbard and others who by that time had made libertarianism a distinctive brand of American political philosophy. At least to the extent of that overlap, the ethic of dialogue or argumentation does justify Rothbardian libertarianism. Since I received the label libertarian because of my work on that ethic, I suppose I may say that my libertarianism is identical to that ethic. Rooted in the philosophy of law, rather than any particular theory of economics, it is the philosophy of people who accept that the ethic of justificatory argumentation is the proper framework for discovering rationally undeniable norms for human interaction as well as justifiable solutions to particular disagreements and conflicts. Advocating such a framework is admittedly far less spectacular than promising a ready-made solution for every conceivable problem. Nevertheless, it is all that libertarian philosophy can offer if it is to be true to the concept of freedom for all persons under the law of reason, and the, in particular cases defeasible, presumptions of rationality, innocence, and self-ownership. With that in mind, it is fair to say that only libertarian rights can be argumentatively justified, because only libertarian rights define a context in which the conditions necessary for justificatory argumentation can be respected universally. A final caveat: the arguments from the a priori of argumentation, and the ethics it entails do not, and are not intended to, supplant the study of the natural law of the human world, that is to say, the natural conditions that mark the difference between order and disorder in the human world. They complement it by proving how we can be rational and argumentatively justify certain actions or statements, if we are conscious of the fact that we, all of us, are in that world. The relative novelty of the word libertarianism should not blind us to the fact that the complementarity of natural law and reason has been known and appreciated for a long time already. Nor should the radical nature of libertarianism blind us to the fact that it is radical only because it presses the demand for interpersonal justification among free and equal persons into corners where the argument from authority, be it God, society, science, utility, or whatever other convenient abstraction, used to reign unchallenged,